So, yeah, I'm going to talk about, as a slide title, better contract, better supply relation. You're probably thinking, well, here's a lawyer. Of course he's going to say you've got to have better contracts, spend money on external lawyers, and you'll use your in-house legal team. But, if you don't use us non-contentious lawyers, the commercial lawyers, I can assure you that at some stage you will be using my colleagues on the contentious side. So it depends on where you want to spend your money, up front or at the end. So what am I going to talk about? I'm going to give you a few top tips, and then I'm going to talk about some of the sort of key issues in sort of strategic procurement contracts. So this is not contracts when you're procuring, say, pencils or paper or toilet paper. This is more about strategic commercial procurement contracts, high value, high risk if it all goes wrong, and some of the key sort of concepts and areas you should keep in mind when you're negotiating these contracts with the suppliers. So some of the top tips: use of standard template contracts. I wouldn't say don't do this, but I would say do it. Keep an eye out on, because for these strategic commercial contracts, if you're using a standard template contract, it will not be bespoke for the particular procurement. So be always wary when you're using standard template contracts when you're doing one of these procurements. My recommendation is to use a bespoke contract, whether it's an IT procurement, a procurement of critical strategic services, procurement of some kind of facilities management. Use a bespoke contract. And if someone says, here's a standard contract for IT procurement, I've never seen a standard contract for IT procurement. So, you're not going to have a standard procurement for IT procurement or any sort of strategic critical thing. Ambiguity. Now, there are a number of contract law principles that apply when there's ambiguity. What I mean is ambiguity is when you're reading the words on the page, it doesn't make sense. Now, obviously, if there's a dispute, you will be arguing a certain position, the supplier will be arguing a certain position. Now, contract law principles, the court will determine what sort of words. Sometimes they impose words, or they basically say, well, the parties intended this to apply, even though the parties may not have intended it to apply. So you need to be very clear. The risk with ambiguity is the court or the judge will impose a certain position, which may not be what you've intended. So what that means is you need precise and clear language to avoid any ambiguity. The devil is in the detail. Yeah, I'm a lawyer. Of course I'm going to say it. But, there's been hundreds, thousands of cases over the years where a little word not or, thou or some other word has completely changes the meaning of the clause. So devil is in the detail. Boilerplate is not always innocuous. So what I mean by boilerplate is that wording at the end, yeah? Waiver, notices, all that kind of stuff where you probably lost the will to live, yeah? By the time you get to that. But, for example, I've seen a force majeure clause. We've all seen force majeure clauses, yeah? Right at the end, I've seen a force majeure clause which says the supplier shall not be responsible for any act of God, event beyond their control, including their own acts and omissions. So if they do something wrong, that's a force majeure and they're relieved of their responsibility. I've seen that in numerous force majeure clauses. So, devil is in the detail. Look at all the boilerplate clauses. Unfortunately, fortunately for lawyers and unfortunately for non-lawyers, words don't always have their plain English law meaning. So you may be reading a word or a sentence or a provision and you go, well, that's clear. But sometimes there's contract law principles and case law which actually change that meaning. So just because it says something, it doesn't necessarily mean that's what it says. So you need to be wary of those. You're all familiar, you're procurement professionals, you're all probably familiar with law changes. They're publicised, we all know when a law changes or, what the impact of that, for example, new briberies legislation, new changes in employment, VAT and so forth. But what you may not be so familiar with is that law also changes as a result of cases. So case law changes the interpretation of contracts. So you need to make sure you know what the latest case law is on a certain provision or a certain concept. there are some common misconceptions in procurement contracts and law. For example, I love this one. You often have a clause saying, you're procuring a service and, you're putting data with the service provider, and you have a clause saying the service provider shall comply with the Data Protection Act. And you go, yeah, that's good. What's wrong with that? Yeah, but service provider, if they're a processor, they have no obligations under the Data Protection Act. So that clause is meaningless. So if you just have that clause, it doesn't mean anything. The supplier will accept it because it means nothing. So in order for the service provider to have obligations, you need to contractually put those obligations in the contract. A clause saying that they will comply with the Data Protection Act is meaningless. Only you as a data controller will have obligations under the Act. The data processor, the service provider, has no Act. So that's a common misconception. There's a number of those, so you need to be aware of those. If in doubt, check. Use your in-house legal team, use external lawyers. If you do have a concern, do check. My view is a good contract is like an insurance policy. You don't want to use it, but if it does go into dispute, you want to make sure your position is robust. But the problem is, what does good look like? We're not necessarily always in the best position to know what good looks like. So that's another challenge. You need to make sure it aligns with best practice, aligns with recent case law, reflects all the sort of common sort of, dispels all the common misconceptions and so forth. So you need to make sure you have a robust contract in place. And it's not simply cutting and pasting, I'm sure you don't do this, words or provisions from other clauses and put it in a contract. You need to make sure it's tailored and bespoke to the particular procurement. So some of the specific issues, limitations and exclusions of liability. I call this a bit of a BlackBerry moment, because whenever this comes up, everybody, sometimes even including the lawyers and procurement people, start looking at their BlackBerry because they don't want to deal with it. But this is one thing you need to engage with. So in terms of a best practice for a limitation or liability clause, unfortunately these clauses become quite convoluted. They start off quite simple, then you have negotiations, lots of clauses, riders, notwithstanding, subject to, and before you know it, the clause runs for 2 or 3 pages. So, all have that experience? Yeah. So what you need to do is step back, when you get to that clause, and ask yourself a number of questions. For example, you need to make sure the clause doesn't cap liability which can't be excluded by law. So it's a bit of an interactive session. You've got to do a bit of thinking. So what are the losses that can't be excluded by law? Death. Yes, death. Yes, death of person or injury. 1. What other ones? Well, you can't exclude some liability under law, so yeah. There's 2 more. Yeah. Second one, what's the third one? The implied title under Supplier Services and Goods Act, yeah? So if you're dealing with a supplier who's trying to exclude those 3 categories of law, you're either dealing with a supplier who doesn't know the law, or you're dealing with a supplier who knows the law is trying to circumvent it. So I don't know which one you would want to deal with. So you need to make sure that your liability clause doesn't cut across those ones. General financial cap. So this is effectively, what is the maximum liability you can sue the supplier for if everything goes horribly wrong. And unfortunately, really unsophisticated approaches has sort of developed for this. There's usually an X percentage of the annual charges or the project price. And I think that's really unsophisticated and simplistic, because your risk isn't necessarily what you pay for it. So you need to think about, what are the losses your business is likely to suffer if things don't go to plan, as opposed to just saying 100% of the annual charges. And what I've seen in recent years is the concept of liability phases, and particularly for IT contracts and strategic service contracts. So, these projects, usually the risk is highest at the initial stages. So you have a higher liability cap there. Then you have the sort of business as usual phase where the liability cap sort of tails off. And then at the end, at exit and disengagement, again, the liability limit is increased because the the service provider, particularly if they haven't been sort of engaged to take over, continue with the services, they've lost the incentive to perform. So you need a higher liability cap to keep them keen. So the liability phase is effectively, if you're doing it like through a graph, so it'll look high like that, tail off, and then high again at the end. How many of you have seen liability phases in your procurement contracts? A few of you have. So that is something which I've seen, as I said, in the last 2 or 3 years. Think about having different financial caps for different categories for losses. You don't want the general cap, whatever it is, to apply for all categories of losses. For example, damage to property. You don't want, 100% of the annual charges to be your cap there if the service provider comes in and, does something and, burns down your premises or damages your premises. You may want categories of loss where there's no limitation of liability. For example, the IPR indemnity, data protection breaches, PCI DSS compliance, or other categories of loss where you think that you want the service provider to be on the hook for much more than the general limitation on liability. Now, customer's liability service provider, often there's no sort of mention of the customer's liability service provider. So what does that mean? Does that mean the customer's liability is zero? Who thinks it's zero? Who thinks it's some amount prescribed by law? Who thinks it's unlimited? It's unlimited. So if you want to limit your liability, you need to expressly set out what the liability cap is, particularly if it's some kind of collaborative procurement arrangement where you as a customer has obligations and responsibilities. Indirect and consequential losses. These are losses which are one step removed from the direct losses. So often under general contract law principle, the service provider is liable for direct losses subject to a cap. Indirect and consequential losses, they often exclude it because it's one step removed. So I guess an example would be if you're buying a piece of software, software doesn't work, the direct cost will be the license fee. The indirect cost may be the cost of re-procurement because that's one step removed. The problem with indirect and consequential losses, it doesn't have a defined meaning. And so in some cases, losses which you think are direct are actually indirect and excluded. So what the best practice is actually deeming those categories of loss as direct losses. So you would deem in your liability clause, say for example, wasted management time, compensation paid to customers, costs for re-procurement as deemed to be direct losses. Then you don't get into a debate when the supplier says, well, we've got that exclusion for indirect losses, so we're not liable. You can show the deeming provision, say, well, you are actually liable because those losses are deemed to be direct. You need to make sure the exclusion limitation on liability clause is appropriate. For example, these clauses can actually go on for, lots of paragraphs. So you need to look at those exclusions really carefully. And one exclusion I always find amusing is, the exclusion for loss of data or corruption of data. You're paying a service provider if they're doing marketing service or an IT piece of work or some kind of, technology development, and they exclude liability for loss of corruption of data. So if they corrupt your CRM or your, other data, they have no liability for it. So check those exclusions and limitations really carefully. Otherwise, you will have no redress for them actually doing damage to your business. IPR indemnity. So this is the wording which effectively, this is to prevent. So under sort of general IP law, software provider or some kind of management consultant comes in, does a piece of work, creates a piece of software or creates some kind of deliverable. Now, unknown to you, that deliverable, that piece of software could be infringing a third party's IPR rights. So why is that a problem to you? Anyone know? They can go after you. Yeah, so the third party can go after you, even though you're the innocent sort of person who's bought that. So what sort of developed is this sort of IPR indemnity. So basically, a service provider will say they will indemnify you for losses, claims, damages, for any third party IPR infringement. Everybody seen this IPR indemnity clause? Yeah? Yeah, okay. The issues here is you need to make sure that the wording is simple and easy to understand, and it doesn't sort of become sort of inconsistent or vague or imprecise. And often we have the indemnity is often drafted. The service provider will indemnify the customer against losses, claims, damages for any third-party IPR indemnity, provided that you notify them of the claim, you cooperate with the claim, you don't prejudice the claim. You all seen those clauses? Yeah. What's my problem with that wording? Yeah. So if you don't notify them of the claim, if you don't do a certain thing, that whole indemnity falls away. So what do you need to do? You need to decouple those two. So you have the indemnity as one clause, and you have the operational aspects of the indemnity as an obligation. So even if you don't do those A, B, and C, you'll be held in breach of contract, but still you'll have the benefit of the indemnity. So you need to decouple those. You need to think about the scope of the indemnity. So, does the indemnity cover third-party costs? Does it cover, for example, legal fees? Often these indemnities don't, and the legal fees can be quite horrendous. I say so myself. So you need to make sure that the indemnity is as wide as possible. Think about the exclusions to the indemnity. Service provider or the supplier will provide the indemnity, but you need to think about what's carved out of the indemnity. You also need to think about the interplay with the liability cap. So is the IPR indemnity, is it unlimited? It needs to be expressly said so. Otherwise, it will fall within the limitation of liability. So you need to be quite express. So step-in rights. So originally these were seen in public sector contracts. This is effectively the principle is to avoid sort of the nuclear option or contract termination. How many of you are from the public sector? A few of you all familiar with step-in rights, yeah? How many of you from the private sector are familiar with step-in rights? Quite a few of you, because obviously from the public sector, these kind of concepts are coming into the private sector contract. So what are the key issues with these step-in rights? Because suppliers don't really like these for obvious reasons. So you need to try to make it as palatable as possible. So, what is the trigger for step-in? Is it a force majeure event? Is it a breach? Is it a material breach? Is it a continuing breach? Is it an emergency event? Is it because a regulator said that you need to step in? So what is the trigger? How long does the step-in last for? Service providers don't like indefinite step-in, so you need to make sure that you prescribe the limit for the step-in and, what actually happens, what is the trigger for step-out effectively. What happens to the charges during step-in? So you don't want to be in the situation where you step in, or you get a replacement service provider in, or bring the services back in-house, and you've got the cost of that as well as paying for the cost of the service provider who's not performing. So you need to make sure you've got the abatement of charges. What if something goes wrong during the step-in period? Who's responsible? What is the allocation of responsibility? And often you need the express provision about third-party support for step-in, because often if you've outsourced or engaged a service provider, you haven't got the in-house capability to bring it in-house. So you need to appoint a replacement third party. So you need to make sure you've expressly got those rights. So how can the effect of step-in be minimised for service providers? Make sure it's only the services affected by the trigger event. Have an obligation saying that you're not managing the service provider personnel, because service provider personnel service providers don't like the customer actually managing their workforce. Often they'll say you can't use a competitor of us as a service provider. If you agree to that, then you get into this old age debate, what is a competitor? As you can bet that the service provider will define competitor to include every Tom, Dick, and Harriet. You obviously want to make it as narrow as possible. Service levels of affected services. What happens to the service levels of the services which they're stepping in? So if you have service credits, my view is it's unreasonable for you to get service credits as well as having the right to step in. So it's either one or the other. Step-out triggers, we've talked about this briefly. There's a lot of focus on step-in in the step-in clause. Often step-out triggers aren't covered. So when do you step out? So this gives visibility to the service provider knowing when the step-in period ends. You may want an obligation to say that you as a customer is acting reasonably, you'll mitigate losses. Now, you'll have to do that under common law anyhow. So giving that obligation doesn't really increase your risk. So, if you want to offer it, many sort of not that astute service providers will think you're making a concession. So you're not really. So, offer that, keep that in your negotiating bag of tricks. Often service providers say that the customer will indemnify the service provider against losses that suffer. Again, be really careful about providing indemnities. Under law, an indemnity, if you offer an indemnity, it's much easier for the service provider to sue you and recover money. So you need to be really careful when you give indemnities. If you do give the indemnity, what is the scope of the indemnity? Is it capped? And so forth. What are the exclusions and so forth? So balanced audit rights. How many of you have come across this case? Oh, you're keeping up to case law, that's good. Really important case in terms of audit rights. Now, this case, I won't go into the facts, effectively said that wide audit rights are non-unenforceable. So that you should really look at your audit rights you got in your procurement contracts. You may think, common sense perspective, we'll have as wide general audit rights as possible. That case said no, you need to be quite prescriptive and specified. So if you need audit rights, you need to make sure what the purpose of the audit is, what you can audit, what is the rationale. You need to be quite prescriptive and defined, because if you've got general audit rights, you might as well not have any audit rights, because the court will say they're too wide, unenforceable. So look at your audit right clauses to make sure that they are in compliance with that recent case. Obviously, service providers don't like giving you audit rights for obvious reasons. So how do you make it more palatable? You may want to say that you will comply with their security and health and safety policies, fairly reasonable. You may want to have an obligation say that you'll minimize disruption when you're doing the audits. The frequency of audits, you may want to say you won't audit more than once every 6 months or 12 months. Scope of audit, you want to make sure that, the service provider knows what the scope of the audit is. Because often suppliers, their main concern is like open book accounting. They don't want to be in the position where you can sort of get their profit margins and that's disclosable. So, unless it's an open book contract, obviously, but if it's not, then you need to make sure that you narrow down the scope of audit. You may also want to sort of provide saying that you'll give them reasonable notice of audit. The one caveat to that is, how many of you are in regulated industries? Yeah, so obviously if you're in a regulated industry, you don't get the notice from the auditor of the regulator that they want to audit your supplier, so you need to make a carve out for when the regulator actually exercises their audits. Benchmarking, so often these benchmarking sort of schedules or clauses can, go on for ages and ages in terms of length. But the general issue is the principle is making, you're comparing like for like to make sure that the deal continues to match what the market can offer. So the couple of sort of issues with benchmarking is how is it sort of structured? So benchmarking, there's two approaches to benchmarking. The first approach to benchmarking is say, okay, I want to make sure that the price you offer me as a customer, you don't offer any other customers a lower price. So that's more inward facing, yeah? The other approach to benchmarking is more outward facing. So what you're telling the supplier is, I want to make sure that the price you're giving me, I can't go to another supplier and get it for a cheaper amount or a lower amount. So that's outward facing. So your benchmarking clause, schedule, provision, whatever it is, needs to deal with what approach you're adopting for benchmarking. It needs to be clear. Otherwise, it's unenforceable, and you don't really have a robust benchmarking clause. So, what is the frequency of benchmarking? Now, best practice is, you should have benchmarking maybe once every 18 months, 24 months, because benchmarking takes a lot of time. It's expensive. How many of you have exercised a benchmarking provision? A few of you. How many of you have benchmarking clause and you never exercised it? A few of you, yeah. So, they do take a lot of time. So, there's no point asking for it every 6 months, 12 months, because that's not practical. Who carries the cost of benchmarking? often the costs are shared, but you may want to say if there's sort of as a result of the benchmarking that need to reduce the prices, you get your costs reimbursed, but then they may say, well, if there's no change, then you reimburse our costs. So it cuts both ways there. What's being compared? Is it pricing? Is it service levels? I mean, effectively, there's only really two things that you should be able to benchmark: service levels, services, and charges. So what's being compared? Normalization. Now, this is a process which basically, all the charges or service levels goes into a black box, and you basically take out all the loss leaders, all the sort of project-specific stuff, so you make sure you compare apples with apples, really. So you need to make sure that there's a normalization process built in. What happens if there's an adverse result? What I mean by adverse result is if you're getting, particular services for, let's say, £10 a transaction, and, you do the benchmarking, you find out you can get it for £7 a transaction. That's an adverse result. So, what's the consequences of this? Now, often I see benchmarking schedules which go on for pages after pages, and they say, if there's a benchmarking, if there's an adverse result, as a result of the benchmarking, the parties will agree in good faith what happens. What's the problem with that? Yeah, so it's a meaningless concept. So, you might as well not have a benchmarking schedule. It does show the intention, but, you can't really sue on intention. So, what are the options to have a sort of, a enforceable and robust benchmarking? You may want to say if there's an adverse result, there's an automatic price adjustment. Now, suppliers will say, oh, hang on, we don't want an automatic price adjustment. That seems a bit risky. So what's been introduced is a sort of degrees of permitted variance or a deadband. So what this means effectively is there's an adverse result. If it's more than X percentage, let's say 5%, then there will be an automatic price adjustment. If it's less than 5%, then basically there won't be an automatic price adjustment. So you basically share the risk of the variation. And then we've talked about cost. Who carries the costs of benchmarking. So compliance with law. Often quite a simplistic approach here. It's been sort of adopted. Most sort of procurement contracts I've seen say customer and the service provider will comply with laws. We've all seen those clauses, yeah? Yeah? Well, what does that mean? How is the responsibility allocation or responsibility compliance actually sort of implemented? That doesn't really get us very far, and that's a recipe for dispute. So what you need to think about is, particularly in regulated industries or where changes to the law will have an impact on businesses, general laws, these are laws which will affect all businesses. So the usual position is both party bears its own costs. Customer-specific laws. So these are laws which are specific because you're in a particular regulated industry. Say, for example, you're a financial institution, you're subject to the PRA regulations. So if there's a change in that, who bears the cost of that change of law as a result of the change? So there's a couple of options. If it's a service provider who does most of their business in that regulated industry, you've got a good argument to say that's the cost of you doing your business, you need to bear that cost. If it's a service provider who has many customers across many sectors, it's a bit more difficult argument to run, so you may want to share your costs and so forth. Service provider specific laws, these are laws which apply to service providers. General principle is service providers shall comply with those, shall carry the costs of that. Remedial plan process. So this is effectively, having a bit more sophistication in terms of breaches. So often you see these clauses saying, the customer or the service provider has a right to terminate if there's a material breach, if they don't cure the breach within X number of days. Fairly simplistic approach. You may want to consider having a bit more detailed sophistication, saying if there's a breach, there's a particular remedial plan process. So the service provider has an obligation to do a root cause analysis. They have to do workarounds. There's assurances in relation to fixing the problem. Importantly, what you want to make sure is there's no obligation to follow the remedial plan, because you may want to be in a situation where the service provider is in a breach and you don't want to be forced that they actually do have to do the remedial plan process, because it may be some kind of breach of confidentiality or data protection where you effectively want to terminate. You don't want them to remedy it because it's not capable of remedy, or if they do remedy, the horse is bolted. So you need to make sure that there's no obligation on you as a customer that you're forced into this remedial remedial plan process. Financial distress, I've seen these sort of schedules and provisions come up recently. It's not a substitute of doing your financial due diligence on the service provider or getting a parent company guarantee, but it does help. So effectively, it's to do with post-signature contract monitoring. So effectively, you have some pre-agreed rights and requirements on trigger of certain sort of specified events. So you may have, I guess, levels 1, 2, and 3, and each of those levels will have specific sort of categories. It could be, for example, credit rating, it could be sort of amount of debt, it could be a number of things. So when a certain level is reached, the service provider has an obligation to notify you. If the next level is reached, they need to establish an escrow amount, so money's paid into that. And if the next level is reached, then they actually compensate you from the amounts held in escrow. So this is to prevent you, being faced with a supplier that you're paying a lot of money and they effectively go bankrupt or insolvent, and then you paid a lot of money, you haven't got the services. So it's effectively to prevent that happening. Obviously, the challenges are determining what those levels are. That can take quite a bit of time and detail. And sometimes, the remedy of them actually paying the escrow monies from the escrow account back to you actually may worsen the situation. So, you may actually force them to go down insolvency route when they may not have. So that's another thing you need to be wary of. So I know that's been a bit of a whistle-stop tour, just a bit of time, but open to any questions. As a customer, you would want to say there's no price adjustment, but the service provider may say, well, we do want a price adjustment that goes upward. But mostly prices, I guess in a particular sector, for example, oil and so forth, prices may go up, but as you know, in technology, it's very unlikely the prices will go up. Any other questions? Free legal advice. You're all procurement people, make the most of it. Get a good employment lawyer, which I do. Obviously if you're doing an outsourcing, there's TUPE, you need specific employment law.
If you're not doing something.
Well, I guess you need to ask the question, when is TUPE applicable? I'm not an employment lawyer, it's a big disclaimer here, but general understanding of TUPE. TUPE applies if there's a particular organised grouping of people or a service which is being replaced by another service. So if you think, if it's a completely new service, very unlikely TUPE will apply. Although TUPE may apply at the end, that's the issue. So because there's obviously at the entry point and then there's the exit point. So it may be a completely new service and you think, okay, TUPE won't apply because there's nothing, it's being replaced. But then at the end of the contract, if you're appointing a new service provider or you're bringing it in-house, then TUPE will apply. So I guess the only situation where TUPE won't apply is that obviously if you're procuring goods, products, or you're procuring a new service which you're not intending to replace or bring in-house. So, obviously you need to sort of build that into your contracts. You probably need to do a due diligence. You probably need to sort of divide the suppliers into different tiers and have, for the more critical strategic one, have a more robust process, and then, materiality drops down. And I guess audit rights are really going to be important on that one. If it's all well and good, like any other clauses, if you can't actually audit or enforce it, then, that's an issue. And I guess with overseas suppliers, the question is, enforceability again, well and good having the clauses, but practically, how are you going to enforce it and implement it? I will be around, so if you want to, feel free to ask me questions, feel free to. But thank you, hope you enjoy that.